All right. Today is November 24th, 2025. The time is now 6 p.m. and I am going to bring the task force to study fiduciary adjudication in Maryland to order. On our agenda today, we have the definition of cases for purpose of report and recommendations, which we have things to go through with that. Then we have the Maryland judiciary data, which we will then go through that information, followed up by continuation from last Monday's meeting, duties and workload for Register of Wills. Continue from last Monday's meeting also, the workload of the orphans courts, and then proposals and possible recommendations, and then analyze the preliminary fiscal information, fiduciary adjudication scenarios related to structural changes in the current court system, finalized by final remarks for the meeting. I'd like for us to go ahead and jumpstart into the definition of cases. Joe?
Yes, sir. Thank you, Mr. Chair. Good evening, task force members. Let me just share my screen. Oh boy. I hope everybody can see that. You see my screen?
Yes, we can see it.
Thank you. Thank you, Holly. So this is data from Byron and that we looked at earlier on in our meetings. And this column is the total cases. We define this as the number of estates requiring action by the court. Defining that as total cases, 29,221. That's on page 3 of Byron's document. On page 4, he broke that number down into contested and uncontested, and that was one of the objectives listed for the task force, is to distinguish between uncontested and contested matters. So this could be contested, a genuine dispute between two parties, or you could add in this other column of a controversial fee. I mean, I guess the disagreement or the concern is about how do you define contested cases versus uncontested. But in Byron's numbers, all three of these numbers in these columns add up to the total number in this column. So this would be total cases. If we can agree on that, we wanted to distinguish between uncontested and contested, but I think there was concern about that. So what we wanted to do for purposes of knowing what the caseload is and purposes of the report, well, data we can put in the report, we wanted to get agreement that this column is good for caseload among the jurisdictions. So I don't know if there's any questions about that. If you have any problems with this column, cases.
Does anyone have any issues and concerns they'd like to bring to the attention of the body? Okay, I see Judge Fisher.
Yeah, I mean, Judge Groves and I have vehemently disagreed with this classification of uncontested and contested because it's just frankly not accurate based on what we see in our actual courtrooms. I have no independent way of verifying this data, but I would suggest that around 5,000 estates are probably what we have. There was another document provided by, I think, Mr. McFarlane. Hold on, there's a lot of documents about the fiscal year 2024 and 2025 that has all the jurisdictions with breakdowns. And do we have that other chart, Joe, that was, I think, for document 2024 and 2025, where it says, you know, orders issued 10,311. I mean, I have a serious problem with, I have 67 contested matters in a year, but I issued 10,311 orders. I mean, I know the rest of you don't have any way of compiling this data, but that's ridiculous. I mean, the classification system, the way unclassified and classified, I mean, uncontested and contested. Sorry, I had a long day in court. I'm having coffee now. Uncontested and contested are classified is simply not true. I mean, a judicial probate hearing, as Judge Groves will probably say soon, that's when people are trying to become a personal representative or admit a copy of admit a will. You can have no one else file against it, but you can have 7 people show up and you can have a 3-hour hearing. That's contested. So this classification, these arbitrary classifications, I vehemently object to being included in any report from this task force because they're just frankly inaccurate. 10,000 orders, 67 contested matters. Explain to me how that actually makes sense.
Well, I'm going to let Byron answer
Yeah.
that, I think, because
Yeah, I mean,
hold on, stand by. I'll
yes,
open it
excuse
up
me, Chair.
for Byron to answer the question, and then we'll go to Judge Groves and then to Delegate Kaufman.
so I from a personal standpoint, and in speaking with members of the public who've been watching these meetings, getting frustrated. I hope we can finally come to a resolution tonight about this constant questioning where this information has come from, questioning what's contested versus uncontested. It's gotten pretty tiresome. When we did, I mean, I don't know what kind of analysis the courts have done. I spent literally hundreds of hours going through each. So for Baltimore County, I went through each and every one of those 5,063 cases, all of them, to determine whether hearings were held and to determine were orders issued, were there objections to anything. If a hearing was held, was it uncontested? When most judicial probate hearings and most hearings that the orphans courts have all across the state, it's usually a delinquent hearing where the PR shows up in the last 2 minutes. It's a judicial probate hearing that just the petitioner shows up and lasts 5 minutes. That's not contested. Like if you believe that that is a contested matter in the sense that you want to compare it to and make it equivalent to a challenge to a will or a petition to remove a PR or a knockdown drag out fight over people, the personal representative misappropriating funds, you're trying to categorize those things as the same, and they're not. That uncontested judicial probate hearing where just the petitioner shows up and no one else, and that's most of the orphans court's hearings. If that's the case, that is more like signing off on an account than it is a caveat. So, we need to be comparing, when we're talking about contested matters, we're talking about 2 parties who are actually in contest, in conflict. When you have a judicial probate hearing and no one objects to anything, or you have a delinquent hearing, or you have a petition to allow a claim without an objection, where's the conflict? That's what I'm not understanding. You say that's contested. Who's contesting what?
Well,
There
in a
is no
petition,
contest.
in a petition to,
I'm speaking.
Stand by. Yeah, one person at a time. You got to be
Um,
acknowledged by the
I
chair.
think we've had enough filibustering, okay? So, I think that, we were commanded to do a comparison of contested versus uncontested matters. If it is the position of the orphans courts that hearings that take 2 minutes are the same as hearings that take 2 days, you can make that argument, but I'm saying that most of the hearings that you have, so that second column, that second category of requires some kind of, there was a controversial fee, but it didn't ultimately materialize into an actual conflict. That also includes someone who files objections to an account and then withdraws them before there's even a hearing. Where's the conflict? There isn't one. Someone files a petition to allow a claim and then settles. Where's the conflict? There isn't one. So I really don't understand at all this desire to try to count these really, uncontested matters as the equivalent to the most controversial things that these courts ever deal with. I think that is extremely misleading.
All right. Thank you, Mr. McFarland. Judge Groves.
Thank you, Mr. Chair. After reviewing these numbers, I asked the staff of my registrar's office, who looked at those numbers in disbelief and printed up multiple pages of all of the contested matters that have appeared in Prince George's County. And this is not including the delinquencies, the show causes and contempts, but these are all most of the judicials that appear before me are two persons who have filed petitions to be appointed as personal representative. We have multiple. In fact, when I sat last week, I had 4 or 5 requests to remove personal representative, and they were all more than 2-minute hearings. I was on the bench most of the day dealing with those. Determination of errors, requests to remove, again, the request to remove the personal representative. I'm just going through these multiple pages that was printed up by my registered staff regarding our contested matters. And we're at about 500 for 2025. So again, this was from my staff in Prince George's County who did not agree with the numbers that were presented.
Okay. Thank you, Judge Groves. Delegate Kaufman.
Yes, Mr. Chair, Byron said he was frustrated, and I'm a little bit frustrated, but for different reasons. In 2 weeks, I have to make some very difficult decisions on December the 8th. And I have to just say I'm frustrated because you have done your very best, but a lot of these meetings are Mr. McFarland and Judge Fisher bickering back and forth. And so my question to you is, uh, you know, as I try to make my best judgment as to what to do, like, what do you suggest in terms of the numbers? Because frankly, but I may be the only person, but I like both Judge Fisher and Mr. McFarland, but it's hard to know who to believe because there's such dispute. So, do you have any advice for those of us who aren't as deeply ingrained in this dispute as to, you know, uh, what numbers we should look at when we're trying to make decisions in 2 weeks?
Like you, Delegate Kaufman, we got professionals on both sides of the argument, and we have an entire staff for this to help us decipher through this information. And so I'm going to point into our help and to the staff that we have with the DLS folks and also with the MSBA representatives. But we'll get through this, Delegate Kaufman and Delegate Bartlett. I see you raise your hand also. So I'm going to go to Jonathan, who is here as a representative from MSBA as one of the support staff for this task force. Jonathan.
Thank you, Mr. Chair. So I think for purposes of our discussions, what we need to look at is the workload carried by judges handling these matters. And the distinction between whether something is contested or uncontested, if it shows up in a courtroom, if it shows up before a judge, even not in a courtroom, it's part of that workload. And so I don't see the contested and uncontested matters distinction being particularly useful for the overall structural issues that we're trying to address in this task force. So I would argue for a definition of cases that includes any matter appearing before a judge.
Thank you, Mr. Lastly. Delegate Kaufman, does that help you at all?
Yes, thank you. Thank you, and thank you.
Okay. Ms. Rowe.
Hi, thank you very much, Chairman. I just want to say just a couple of things, and I'm coming from the fact that I was on the Orphans Court, and it's a medium-large county. It's not the same as Prince George's County or Baltimore County. And then now being on the register side, I just remember being on Orphans Court. It's not that difficult, and it didn't take that long to get the work done. And the hearings that we had, yes, there were hearings where I think I can count on my right hand, maybe, and I was only on there 3 years because then I filed to run for register, maybe 3 hearings that took over 3 hours. That was it. And I don't see how Baltimore County and Prince George's County had these major hearings. I did not experience that. So I know it's just not true. And that's the experience that I had. And what I'm seeing now in our orphans court, they're not on, it's the same thing. So I have real issues going on here with people challenging these numbers. Thank you.
Yeah, I can't speak for the courts, but what I will say that every jurisdiction is different, Ms. Rose. So you got to take those things into consideration.
I do. I'm sorry. But we've only looked at 2 courts. Let's look at their other courts. That's all we've looked at. It's been centered around Baltimore County and Prince George's County. There are a lot of other counties out there that we have, I'm representing one, but I'm on the task force to say it's not that complicated.
All right. Thank you
Thank you.
Thank you for your input, Delegate Bartlett.
Thank you, Mr. Chair. I am of the mindset where Jonathan was going with, actually trying to define, not so much, the definition of cases, because it is important. I think, or I thought where we were going is we're trying to figure out what is the workload. I agree with Jonathan on that. And I was starting to, go down a rabbit hole that I don't know that we need to go down. And that's where I was starting to list the type of cases, but that's not really the issue. It seems more to be just the cases in the aggregate. And it's not, isn't it more the case of in the aggregate at this point than the case with respect to type? I know that one may assume that a certain type of case will take a longer period of time. But from what I'm hearing from Judge Fisher and Judge Groves is that it actually depends on, like any other case, on the parties. I mean, you could have a very, something that you think in court is going to be simple, but you get the parties together and it could take a lot longer. So it may look like you only had one case that day, but if it was one case that took all day, then and if we defined it as merely the type of case, and that is I don't want to use the word contesting, that is request to remove a personal representative. Well, while it may seem like it's just a request on one side and the other person makes their arguments and the judge decides, it sounds like it could take a lot longer period of time, or even a request to become a personal representative. As Judge Fisher said, there could be 8 people asking to become a personal representative. So could we, my question, I guess I'm getting at, and I do have a question, Mr. Chair, and that is, do we agree at any level with respect to the first column, the number of estates with activity of any kind? Are we even close to agreeing on that might actually be something that seems plausible? Or are we stating that in itself is not even within the ballpark of the way the actual folks who do this work every day, feel that it is in their counties?
Well, before I allow you to go, I see Judge Fisher. She raised her hand. I'd like to get her to chime in and answer on behalf of that question.
I would agree with you, Delegate Bartley, and Judge Groves and I have said over and over again, we don't want this to be about numbers. This isn't about numbers. This is real life here we're talking about. And I would agree that somewhere close to 13,000 estates have activity in Baltimore County. I can't speak for the other jurisdictions, but I can tell you that that seems accurate. And I think that this chart is more reasonable. It's the chart with the differentiation between contested and uncontested that Judge Groves and I have an issue with. I would be fine using the numbers on the current chart.
Delegate Bartlett, does that satisfy you?
Very much. Thank you, Mr. Chair.
Delegate Kaufman, does that satisfy you as well?
Yes, it does. Thank you.
All right, Jonathan?
Sorry, Mr. Chair, I was going to make the same point. I agree with Delegate Bartlett as well. So if we can use what I'm going to call the blue chart, I'm good with that.
All right, and Byron, are you fine with that as well? I just want to make sure we got buy-in from the team. Everybody is fine with this chart.
Yeah, and just very, very briefly, Mr. Chairman, I think that the schism is really more over it is to some extent what my colleague Ms. Raleigh said. It is also that, some jurisdictions do have more conflict than others. And unfortunately, we really have only heard, as she said, from 2 counties that are high conflict counties, and high caseload counties. So we're not hearing from Dorchester County or Caroline County or Washington County. And I think that where the kind of work that the courts do, we can maybe put that aside for now. That will become relevant, I think, when we look at some of the proposals for reforms and we start looking at, if these 29,000 cases, for example, are moved over to circuit court or some other kind of court system, what does that really mean in terms of man hours or woman hours, not to be pejorative. So that, that's where that'll kind of come in again, I think, down the road. But I think I'm fine with us moving forward with this.
All right, thank you. Sounds like everybody's in agreement. So Joe, we can use this information. And so with everybody's points, what I will say is, with all the other courts who were not able to provide any other information, we will be having a public meeting next month. On December 1st, and it'll be open to the public, so everybody can come in and chime in and say what's needed to be said, so that we can get a proper understanding from everybody. So, open meeting on December 1st. So, if we're looking for more information, please have your folks join us on that call, and then they can make any recommendations they would like. All right, Joe.
Thank you, Mr. Chair. I have some additional data from the judiciary.
Joe, do we need a vote on the definition of cases?
Do we, Holly?
I mean, it seemed like everybody was in agreement, but I'll defer to the chair if you'd like to.
Yeah, we can make a motion. Anyone want to offer a motion?
Move to accept the chart with the blue headers.
Second.
It's been moved and properly second. All in favor signify by a sign of aye.
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 Any opposed? Signify with a nay.
Mr. Chair, I just want to say this is Judge McQueen. I'm not voting, so I just want to make that clear for the record.
Yeah.
Okay. Thank you, Judge McQueen. All right. Sounds like the ayes have it.
Okay, thank you. Thank you, Laura. I had reported earlier to the task force some numbers from the judiciary regarding fiscal year 25 for trustee cases and guardianship of the minor cases. And I know there's some concern about the trustee cases, that those numbers might not represent what actually happens, but I have got some prior years, fiscal year 25 through fiscal year 24 for these same categories, just to give context, just to see, are these numbers stable or are there any variations? So in fiscal 25, there were 53 trustee cases filed in the circuit courts. But as you can see, in 24 it was 76, fiscal year 23, 64, 41 in fiscal year 22, and 56 in fiscal year 21. So I interpret this as they're rather stable figures, not a lot of variation among the 5 years. And then with respect to the guardianship, this is detailed, but it's kind of hard to look at. I had reported for fiscal year 25 that there were 1,346 total guardianship in the minor cases filed in the circuit court. And I added these up. So again, it's the totals are not easy to read. So in fiscal year 2025, it was 1,346. In fiscal year 2024, it was 1,165. In fiscal year 2023, it was 1,089. In fiscal year 2022, 925. In fiscal year 2021, 714. So the big increase between fiscal year 2021 and 2025 is in the guardianship of the person and property. I see those numbers as stable. So there's been an 2.5 increase in guardian of the person. So there's been almost in total guardianship of the minor. It's gone from 714 in fiscal 2021 to 1346 in 25. So it's almost doubled, but that's the caseload. That's the just something that for you to have that information for you to have. And also, excuse me, the appeals. So I had reported for fiscal year 25 about 60 appeals, and you could see the numbers below for the prior years. I interpret these numbers as rather stable, or on or about the same amount. So I don't know if anybody has any questions. Just wanted to report that.
All right. I see Ms. Petriotti had her hand raised. Then we'll go to Delegate Bartlett, then Mr. McFarland.
Thank you, Chair. My concern about the trust cases is that most trust cases, when they are filed, do not have the word trustee in them. Under Rule 10-501, very often you must file what's called a petition for assumption of jurisdiction. That requires you to identify the case as in re and then the fiduciary estate, whatever the trust is called. So if we are only searching by case captions that involve the word trustee, it is going to be overly limiting of the trust-related cases.
All right. Was that just a statement, Ms. Petriotti?
Just a statement. Yeah, it's preterati. Sorry, it's a hard one to say. It's just a statement to highlight that I think there are more trust cases filed than are actually being reflected in the data. And part of the issues that Section Council has raised is the fact that we have trust cases being decided by a different forum than estate cases, even though there is significant overlap among the issues. So I just want everybody to understand that there are likely quite a bit more of trust-related cases that are being filed in the circuit court on a yearly basis.
Okay, thank you, ma'am. Delegate Bartlett.
Thank you, Mr. Chair. Joe, I trust your numbers. I just didn't understand them. Can you go up on the guardianship? What I was looking at wasn't what you were reading, and I'm just trying to make sure I understood what you were saying.
Yeah.
Like I heard you say something, a 700 and something number, and
Well, they're not added, so.
Oh, oh, okay. Okay.
Yeah, so I added 487, that's 487 plus
Mhm.
82 plus 145. See,
Yeah, that's fine. That's
yeah,
all it
it made
was.
it,
I knew
yeah.
I knew what you were saying was right. I just couldn't follow along with you.
No, it's
And,
hard to
and I
see
get
it.
what you were saying now. Okay. Thank
Yes,
you.
ma'am. You're welcome.
All right, Mr. McFarland.
Thanks, Mr. Chairman. Joe, if you could, I think it was in maybe one of your emails or a notation somewhere, just to note, if you could scroll back down to appeals, that's the number of appeals that are filed in circuit court. That doesn't include, just want to note that it does not include appeals that are filed with the Register of Wills, but aren't ultimately pursued. So that would include cases where an appeal is filed as a litigation tactic, or someone decides it's just not worth their time for whatever reason, it doesn't actually make it all the way over. I just wanted to make sure that you could just confirm that that is accurate.
Oh,
Joe.
this data, does it include that? Is that?
Right, right. And I think you made a note of that somewhere, I don't, on some other document, but just
Okay,
to,
yes, that's my
okay.
understanding.
Okay. All right, thank you.
Sure. Mr. Chair, I don't know if we want to vote about the trustee, whether that data ought to be included in a report, since there's concern about it, about the numbers. I leave that to your discretion.
Ms. Praterati.
I was just, Joe, is it possible to search the cases by the word trust and then back out any like deed of trust cases, or if we're seeing like a group of cases that are outside of the scope of what we're discussing, we could eliminate those?
Well, I originally asked to look under the word for trust case, and the judiciary indicated they don't have that case type. They indicated they had the trustee case type.
Oh, interesting. Okay, so they're
So,
not searching by names. There is on a civil information report, I do think you have to click a box if there's a petition for assumption of jurisdiction. I'll look at that while we're talking and let you know. That might be another way to bring in the other cases that are not being selected as trustee cases.
okay.
Yeah, Joe, to answer your question, if it's going to be this difficult to pull the information and separate it out until we know, I think it's best to hold off voting on breaking that information out separately, because it seems like it's a little bit more difficult than it is easy.
And I think we need to reach out to Maryland Judiciary and confirm what's possible and what's not possible. So we can do that.
All right, Jonathan, I saw you had your hand up, then you took it down.
Yeah, Joe and Holly have addressed my concern, so I think and you, as you have as well, Mr. Chair.
Okay. All right, Ms. Praterati, do you have anything else you want to offer?
No, I'm just delinquent in lowering my hand after I raise it.
Oh, that's okay. All right, Joe, do you have anything else?
No, sir. Not right now. Thank you.
Okay. All right. So we're gonna go next to last Monday's meeting, the duties and workload of the Register of Wills. We're gonna bring in Mr. McFarland and Ms. Roll.
Yeah, thank you, Mr. Chairman. We thought that it might be useful in speaking with Holly and Joe to make sure, and maybe we should have offered this earlier in the task force, but just to make sure that everyone understands especially for the public watching, most of the people here understand, but mostly to the public watching and to members of the legislature, what exactly is the duty of the Register of Wills? And we primarily serve the public. The role that we play as clerk to the Orphans Court is a very, 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 very small part of our job. And so I thought it might be useful to kind of explain. I'm going to hand it off to my colleague, Mary Raleigh, just to give you an understanding of what we do every day. And I'll close out, and I hope we're not going to take the full 10 minutes here, by highlighting the problem that exists under the status quo with the orphans courts not having staff. I think that it's a problem for them, it's a problem for us, and it's something that I think really needs to be resolved. And I really hope that whatever we come up with as recommendations at the end of all this, that we can agree that courts in our state, every judge should have some kind of dedicated staff to them to help them with orders, to help them with their calendar, whatever it is, that they should not be relying on anyone else for that. So it's a point of common frustration, and I'll close with just highlighting that. But I'll hand it over to Mary now, if you want to go ahead, Mary.
Yes, thank you. All right, so I'm going to go over some things, as I said, maybe under the 10 minutes. And this is stuff that we do basically every day. It doesn't include stuff that come up as kind of emergency or dealing with certain issues. So to go over, we appoint deputies and clerks to operate the office, and that can be anywhere from 2 to 38 employees. We oversee the administration of probate estates. We accept all papers for filing. We maintain estate dockets and issue court orders. We serve as custodians of records for all estate proceedings, depositing original papers and periodically within the Maryland State Archives. We certify records to the circuit or appellate courts upon appeals from the Orphans Court. We record and maintain records of all court proceedings. We provide copies of records to the public upon request. Serve a primary procurement officer for the office. We collect probate and other fees on behalf of the state of Maryland, transmitting excess revenue to the Comptroller of Maryland on a monthly basis. We calculate, assess, and collect inheritance taxes, transmitting excessive revenue to the Comptroller on a monthly basis. We certify to the Comptroller of Maryland payment of any inheritance tax for the purpose of determining liability for the estate tax. We audit filings in all estates to ensure proper payment of fees and taxes. We are subject to and obligated to comply with period audits every 3 to 4 years by the Office of Legislative Audits for Fiscal and Compliance. And we actually have done that this year. Our office many offices just had that this past year. We receive and confidentially store wills of living persons for safekeeping. We register domestic partnerships to qualifying residents. We serve as members of the Maryland Register of Wills Association, comprised of registers for each of the 24 jurisdictions, and is expected to serve as an officer or chair member of at least one committee of the association. And the last thing I have is we have an affirmative duty to engage in public speaking and distribute materials to educate the public and on the probate process, which speaking for myself right now, I'm out a lot of nights right now speaking to the public, explaining what we do, answering questions, a lot of elder conferences and things like that we attend. So that's on a daily, monthly basis. And as I said before, that doesn't include anything that might be coming in that's out of the ordinary. Thank you.
And to pick up on where Mary left off, that's really what the bread and butter of our work is, and especially for the practitioners here, you know that. But as far as our duties to the Orphans Court, it really is very clear under law, and there is a 2013 Attorney General opinion on the Orphans Court's ability to exercise authority or direct or discipline registered staff. That is part of the public materials that everyone should have, that really was definitive in making it very clear that, our staff answer to us, they work for us, they are at will. And as far as our duties to the courts, the really simplest way to explain it is that when a matter is ripe for the court's attention, we put it in front of the court. When they issue an order, we dock it, image it, and mail it to all the interested persons. We staff the courtroom to record hearings. If anyone requires a copy of a hearing, we provide it. And we set in hearings. And otherwise, we're the kind of, we're the front line when people are calling their government about a probate matter. They call us and we talk to them. So, and it's only a couple of orphans courts. I think it's just Baltimore City, Baltimore County, and Prince George's that have staff. So every other court doesn't have any employees. And what that leads to, and I'm going to try not to go down a rabbit hole here of examples because some of them are, from an employment law perspective, extremely problematic, but some of the things that, we by default basically become their staff, and we are asked to do things that are above and beyond what the law requires us to do. And that's anything from things that are quasi work related, like legal research. There is nothing in the code that says anything about the registers having a duty to advise the courts on the law, explaining the law to them, but we do that. But it also veers all the way into the personal. Towards the end of my last term with the court, we had a judge who, and this gets to kind of a sensitive issue that we don't have a mandatory retirement age for orphans court judges. We had a judge who was 79. She was really kind of sadly losing her vision. And so we had to read documents aloud to her. That's so far way above and beyond, obviously empathetic with her situation, but that's so far above and beyond what our duties are supposed to be. And so that creates an extraordinary amount of conflict. It's also a conflict because all the judges, with the exception of the judges in Baltimore City, are county employees and we are state officials. And we have had issues where we have had very significant points of conflict because of judges creating a hostile work environment for the registers and their staff. And actually, even among the judges, under my last term, one of the judges felt that another judge was so hostile to her that she couldn't come into work some days. That touches also on the fact that I don't think that there is any justification for 3-judge panels for these courts anymore. We're the only state that does it. That's another source of concern. So I want to just lay out again with my colleague what our duties are, what they aren't. And I do suggest that when we look at recommendations, and again, I hope we can be unanimous on this, whatever judge is handling a probate matter should have their own law clerk, should have their own secretary, so that these kinds of conflicts, and by the way, that conflict that we had here in Howard County, it simply evaporated overnight as soon as we transitioned to the circuit court. And that conflict doesn't exist in Harford or Montgomery counties at all. It simply vanishes with the reforms that we've made. So I just wanted to make that clear for those of you who may not be as familiar with our role and what we do day in, day out. And I'm happy to answer any questions.
Delegate Kaufman.
Yes, thank you, Mr. Chairman. Can you tell me, Byron, how your offices are funded? Are you self-funded through the fees and stuff you collect, or through tax dollars, or how are you guys funded to
Yeah,
pay
so
your
when
staff and stuff?
that's a great question, Delegate Kaufman. We take in through the inheritance tax and the probate fees that we collect, that funds our offices, and what we don't need for payroll and office supplies, we turn over to the comptroller every month.
Are you on a meeting?
Thank you, Mr. Chair.
All right, thank you, Delegate Kaufman. Judge Groves.
So the Estates and Trust article, thank you, Mr. Chair. The Estates and Trust article states that the Register of Wills is the clerk of the orphans court. I don't know why that seems like that's a dirty word, the word clerk, but the statute further says that the register shall serve as the clerk to the orphans court as a clerk to the circuit court serves as a clerk. So that means that if orphans court does not have its own staff, as yes, I am fortunate enough to have my own staff, but if it doesn't have its own staff, then the Register of Wills should supply somebody from his or her office to serve as the clerk of the court. So since we have our own courtroom clerk, we don't need a clerk from the Register of Wills office, but someone from the Register of Wills office does come and serve as our bailiff. So we do have someone from the Register of Wills office coming over when court is in session to act for the court. So I don't know why that's such an issue. I can't speak to the allegations that there are personal things being done in other jurisdictions because, again, as has already been stated, other jurisdictions are not here to speak for themselves. So it's kind of unfair to state what's going on in other jurisdictions. But if that's what the statute says, then that's what the Register of Wills should not have a problem to do, to serve as the clerk of the court. But I do have a question. I know that there's been this emphasis on the fact that there's no any type of educational requirement for judges outside of specific jurisdictions. I don't think that there are any educational requirements for registers. If I'm mistaken, please let me know. I know that there are 3 who have JDs, 1 who has a master's, a couple who have bachelors, but the vast majority of them have high school education and nothing beyond that. So given all the vast duties that have been stated to be, I don't know if they're complex or not, but what type of educational or continuing education is going on for the Register of Wills? How are the registers that are, when they're newly elected, how are they trained? Who's training them? Same type of questions that are being asked for the judges, particularly since the register is the clerk of the court. It's important to know who's training the registers, particularly since there are no education requirements. And also, if I can just add, since it's been brought up that the orphans court is antiquated, that throughout the country, there are not that many orphans courts anymore, that they're being abolished. Just a point of fact that the Register of Wills is an antiquated office. There are only 2 other jurisdictions or 2 other states that have a Register of Wills, and the District of Columbia. That is an antiquated office as well. So if we're looking at doing something and reforming the Orphans Court, we need to look at reforming the Register of Wills as well, and maybe lump all of their work into the Clerk of the Circuit Court.
Thank you, Judge Groves.
If I could
Mr.
respond,
McFarland?
well, first off, here's a stack of comment cards that are all thank you letters to me and my staff for the work that we do. And this is just from the last few months. So it's also not germane to this. I know you would love to bring the registers into this, but our training and our education requirements and our stature is not the subject of this task force. You can go and reread the bill if you have to. And as far as our job as clerk, and this is in a document that'll be made available to the committee or the task force next week. Yes, we are the clerk of court as any other clerk would be. That does not mean research assistant. That does not mean, and again, to task force members, you know, just as Judge Grove seems mystified why we don't understand it, we also don't understand why the orphans court judges don't understand what clerk means. And it does not, it is used by the judges in this basically limitless, you must do whatever we need you to do. As my colleague just shared with you, we have a lot of work to do every single day. You know, we've got to do a bank deposit every day. We've got to answer the phone every time it rings. We've got to report all of our state work, and we've got to report our revenue to the comptroller every month. All of that takes a lot of time, and we almost always get perfect audits. But when it comes to our duties as clerk, that is defined in Courts and Judicial Proceedings 2201 definitively, and nowhere in that list does it say staff a court if they just not so happen to not have staff. So it talks about keeping custody of records. It talks about issuing orders. It talks about receiving documents and administering oaths, but it has nothing to do with anything beyond that. So that's the limit of what the registers are supposed to do. And the problem here, to put a fine point on it, is when we have county employees who are coming into my state office, and in my case, I had judges trying to discipline my employees. I had judges scream at my employees. I had judges question their intelligence. and this happened. You can roll your eyes all you want, but I mean, these things actually
All
happen.
right.
You know,
Let's keep it to the points.
so the point is that we, under the current system, we have a system that inherently is going to create for the staff of the registers an employment problem. You know, who is my boss? And they work for the registers and they work for the state. They don't work for the counties or Baltimore City, and they don't work for the orphans courts. But that line is constantly crossed, and it creates, you know, it's the reason why we had to have an AG opinion on the authority of the judges over the registers. That's how serious it became in Anne Arundel County at one point. And so, you know, as you can tell, this is a serious problem that, you know, we already know how to, in Howard County, this problem doesn't exist anymore because we have a circuit court that has its own staff. Not a problem. It literally, a lot of the things that we're talking about are hard to resolve. There aren't necessarily easy answers. This is an easy one.
Thank you, Mr. McFarland. I just want to piggyback off one of the things you said in terms of you guys don't have that problem in Howard County because it's under the circuit court. And it seems as if there is not a problem in Prince George's as well because they have staff, and it goes back to one of the recommendations that you made that we'll have to all end up voting on and making other recommendations, which is probably folks all need staff. But Senator West, I was hoping that you were going to chime in, being that this was your bill.
Well, that's why I decided to raise my hand. I don't think I've chimed in yet. I've been taking it all in. I must say, when I introduced the bill in the Senate, I never expected that these meetings were going to devolve into what they seem to have devolved into, which is constant attacks by the Register of Wills on the orphans court judges, and then the very defensive responses by the orphans court judges and lashing back at the Register of Wills. This is not at all why the bill was conceived. And I think it's really getting away from the purpose of the bill as we originally conceived it. I think Delegate Bartlett would agree with me. We weren't intending to precipitate a war between the Register of Wills and the orphans court judges. I would hope that in the remaining time we have together, that everybody would try to be accommodating and respectful of each other, and we'd stop these constant attacks. I don't think they're useful. That's my feeling.
Senator West, you hit the nail on the head. Can you just kind of, from your perspective, being that you were the author of the bill, just reiterate back to the public and to the task force what exactly your intent was for this particular piece of legislation?
Well, I'm sorry. Okay. I thought I muted myself again. There was a task force a couple of years ago that I participated in dealing with orphans courts, and we made a couple of suggestions at the time, some of which have been adopted, others haven't. And I thought this task force would be a continuation of that, and we would try in a mutually respectful fashion to figure what the problems were with the orphans courts, and then try to make reasonable recommendations about how the problems could be fixed. Jonathan Lasley worked on the bill with me in the Senate. I think he probably could further explain what we had in mind. And it certainly was not to precipitate a war between the registers of wills and the orphans courts.
Jonathan, did you want to join in on the conversation?
Yes. Thank you, Mr. Chair. I agree with everything Senator West said. So the previous task force was limited to looking at the orphans courts only. And as we in the bar were reviewing those recommendations, we realized that they really didn't go far enough to cover the whole topic of fiduciary adjudication. So not just probate, but trust matters and so forth. And so what we were hoping for was a discussion not on how the orphans courts per se are structured, but how do we handle fiduciary adjudication as a whole in Maryland. And as Kelly has pointed out this evening, matters have changed over time from over the hundreds of years that the orphans courts have existed. So the matters of estates and trusts have become much more complicated, much more interrelated between the jurisdictions of the circuit courts and the orphans courts. And so what we're hoping that we can do in our remaining time is to discuss how do we best serve the people of Maryland and provide equal access to justice across the board on all of these matters, and hopefully improve the efficiency of them. That doesn't go to the relationship between the Orphans Court and the Register of Wills per se. It goes to what are the big global issues to look at? Yeah, those issues may come up as we get into nitty-gritty details, but our overall focus are these big global issues of efficiency, access to justice, jurisdictions, that kind of thing.
Delegate Bartlett.
Thank you, Mr. Chair. I wanted to let this flush out before I made my comment, my question. My question is a little bit different. So Mr. Chair, I just want to give you that forewarning in case you wanted to flush out this conversation some more.
No, I think Senator West, he made some poignant points to this, and then so did Mr. Lasley. So I think we flushed it out just enough, and then now we can tap into what you want to bring to the table on the conversation.
Okay, so what I wanted to talk about, and maybe Senator West or Jonathan can help me with this, and that is the role of the comptroller. Because I was looking, and I didn't know if it might have been discussed in the previous task force, but it seems like the comptroller's office, when I look at this this document, which is the attorney, I think, I'm not sure whose opinion this is. Actually, this is this is the I don't know, it's Testamentary Law, General 231 from 2013. It was a question on the authority of the Orphans Court over the Register of Wills, et cetera, and duties, et cetera. In this document, the comptroller is given the authority. I'm looking at page 27 of this document. The comptroller is given the authority with respect to personnel matters. That is the comptroller, not the Orphans Court, who sets the number and compensation of assistant clerks or deputies employed by each register. So my question is, one thing that I was hearing tonight, and I've heard before, last week, is, not every county has the same resources. Right? Is that a fair statement? I think, Jonathan, maybe I'll look to you on that one, if it's okay, Mr. Chair.
That's correct. That's okay.
I actually, in terms of how much each county spends, I would defer to Joe and Holly on that. So each county, as I understand it, each registrar's office brings in fees and inheritance tax, and the inheritance tax is far and away the biggest piece of that pie. And then the registers as a whole are funded from that pot of money, and then any excess is refunded to or not refunded, but sent to the controller on a monthly basis, as both Mr. McFarland and Ms. Raleigh have stated.
With respect to staff or case management, that's where I was going.
That is determined through the controller's office. You are correct, as part of the budgeting procedure, and it does go in front of the budget committees as a sub item. Or I can speak to 30 years ago. Let me put it this way: 30 years ago, it went before the budget committees as a sub item within the controller's budget.
Okay, all right. And so if more staff is needed, or deputy clerks, I think it was said in there as well, is needed, then that is something that would be requested by the comptroller's office in their budget, presumably. Holly and Joe, is that correct?
That's my understanding, but we haven't looked into that aspect. in any depth at all. I mean, I think you're referring to the AG opinion, which I did read, but I haven't looked into that.
Okay. Okay. I was just wondering because I know we've heard from, a lot of folks, and this has been very helpful. I was just wondering, not to add anything to anyone's workload, if we need to hear anything from the comptroller's office, if we needed to go in that direction. That's why I was asking that question, because it just seems to me that if folks are having to, obviously the larger counties are going to have, I'm presumably a bigger pot than some of the smaller counties. Although I don't know what Anne Arundel County has, which is my county. I don't know if there are staff members or not. But anyway, my point is that I'm hearing different things, and I was just wondering about that. And I just wanted to kind of give some food for thought with respect to the comptroller's office.
Thank you, Delegate Bartlett. Mr. McFarland?
Yeah, if I could just to elaborate on that, Delegate Bartlett. Yeah, so the registers, constitutionally, we are part of the judicial branch of government, but operationally, we function more like executive branch agencies, and it is the comptroller's office that oversees us. So they approve our staff. They assist us with our IT contract, all that kind of stuff, all of our budgeting. And I'll just say, from having spoken to a few clerks about what we're talking about here, I actually kind of wish that we had a clerk present, since we're talking about potentially shifting duties from the from one part of the judicial branch to another. But in any event, like if the registers were to take over, or the orphans courts were to take over, trust cases, for example, like what would that mean for us? Like, at least here in Howard County, we have the clerk's office has two employees who spend part of their time on adult guardianships and trusts. So that says to me that if we were to take over trust matters, or the orphans court were to take over trust matters, or we were to move into some kind of fiduciary court model or something, I'd probably need maybe one more employee. So, and Howard County is the 7th most populous county. We're right behind Anne Arundel, actually. So, it might be something relatively similar in your jurisdiction. So I just wanted to add that.
Mr. Chair, if I may, can I just ask one more quick question?
Yes, Delegate Bartlett.
So my question is, this is for Mr. McFarland. So with respect to the change that Howard County has now seen, with having the orphans court as part of the circuit court, or I don't know if we have anybody else from any other county that present that has done that. But Montgomery County, I guess, has. But my question is, with that change, did your budget change as well? And do those fees still go under the purview of Register of Wills, right? And you still, like you were saying, you still have to send over to comptroller's office, whatever you do, whatever you have to send over. I'm just trying to see, how does that change if there is a change?
That's a great question. And the answer to that is that, so the Register of Wills office, our budget didn't change at all. My staffing level didn't change at all, because the orphans court is funded by the county. Howard County ended up saving, they had 3 judges, their expenses, and they had a part-time employee. Howard County now spends $100,000 a year, roughly, less, because they no longer have an orphans court. The circuit court took over our former orphans court's part-time assistant, made him a full-time employee. I think it's something Judge Tucker may have touched on last week. So they didn't need a new magistrate, they didn't need a new judge, they just needed one support staff. And I don't know his salary, but that was the only, so budget-wise, Register of Wills cost does not change at all. The county is now saving money, and that cost essentially was shifted to the circuit court.
All right.
Thank you, Mr. Chair.
All right, thank you, Delegate Bartlett. Listen, we spent a lot of time on the the Register of Wills, I want to make sure we give some time to the clerk's office as well. And then also go to the bread and butter of why we're here on this task force is the recommendations. And there is a bunch of different recommendations that are in a proposal that we can discuss also so that we can figure out where everybody is prior to the December 1 public forum. But I'm going to open it up now to our judges. Judge Groves, if you want to jump in and continue on your workload.
Okay, this just very briefly, I submitted a report a couple of weeks ago with respect to the administrative work of the court, what we do, what we call chambers work, the paperwork that we do. Review after the auditors and the Register of Wills office has looked at accounts. Then they come over to us for us to approve. There are various petitions that will come before the court, petition for attorney's fees, petition for commissions, personal representatives commissions. We review those and make a determination as to whether or not we're going to approve those or reduce the requested amount. We set in hearings if there's a request for any type of hearing, such as exceptions to accounts and petition to caveat, petition to remove personal representative. So if those petitions come before us, we review them, make a determination as to whether or not it needs to be set in. And we've already discussed, I think, in previous meetings, the type of hearings that appear before us. We've already talked about the determination of heirs, the different types of heirs hearings, common law marriages, whether or not someone is a common law spouse, whether or not someone is a child of a decedent or an heir. We hear those type of cases as well. There's nothing much more to add than what's already been stated as far as, and one thing I did not include was writing opinions. So if there is a matter before us and we want to take the time to what we call taking it under advisement, and because we want the parties to have a clear understanding as to how we arrived at our decision, we will do a written opinion and order along with that. So that's included with our caseload and casework as well. Anything else you want to add, Judge Fisher?
I'd just add also there's motions work, there's discovery motions, there's sanctions, there's any number of weird titled hearings and petitions and motions that people file. Pro se people particularly come up with some very creative titles for hearings that we have, and the augmented estate, and we've discussed in all of those detail. It's just a lot. It is a lot of work. With respect to just one question about the register's funds, just to follow up for Judge Delegate Bartlett, is I know in Baltimore County last year, the Register of Wills brought in Baltimore County registers brought in $16 million. So the state's pretty loose and flexible with their budget and their needs and staffing needs, because I think that they're probably the only office statewide which operates on a huge amount of surplus, at least in certain jurisdictions. I'm sure there's some jurisdictions that don't. I think I glanced at the chart once, but I only have the Baltimore County information. So if our Register of Wills office, even cost $1 million, the state's still ending up with $14 million in additional funds that go to the general comptroller. So it's, for the most part, a pretty profitable office for the state of Maryland. So I don't know if that helps clarify any of that for you.
Did that help out for you, Delegate Bartlett?
I think there is a chart, Delegate Bartlett. I'm sure Mr. McFarland could get it for you, which shows which each county brings in through fees and through inheritance tax. Mr. McFarland, is that something that you have that you could provide, Delegate Bartlett?
If you look at the governor's budget and his attempt to eliminate the inheritance tax this past session, there's a ton of data there. But if there's anything specific that you want, Delegate Bartlett, I'm happy to get it to you.
Great, thank you.
All right. Is there anything else that the judges would like to add?
I just want to say that when parties appear before us, we do have a colleague who happens to be a lay judge, and she says that our court may be the only court that a person appears in. They may not go to district court for a traffic ticket. They may not go to circuit court for whatever matter, but everyone is going to face the death of someone at some point, and our court may be the only court that they appear before. And I do believe that the judges, whether they are attorney or lay, they have compassion on the people. I like to tell people that we are dealing with those who have a mixture of grief, but also greed and entitlement. And so in understanding that, we have to deal delicately with these people, knowing that they're appearing before us. They've got a mixture of anger and tears, because we're dealing with family members that are fighting with each other. So it's not a typical type of court, because we are dealing with family issues and hurt, and people are going back years talking about whatever their experience was in their family life. And I do believe that our court serves an important purpose. Our court has been here, been around since the 1600s, 1700s, and there's always been attacks on it, but it has survived. It evolves, but it serves an important purpose. And all the judges really do care about their work.
And to follow up on that, I had a case today where a woman's daughter had passed away, and she's now caring for her grandson. And she'd been before me a couple times because she's done a lot of things that were not legally proper. And she's trying to protect the assets in a guardianship at best, and there's real property, and it's complicated, and she lost her daughter. So there's a lot of empathy. And today she managed to get an attorney finally. They've gotten the guardianship straightened out. And she brought me her grandson's report card. And he's 14 and he has straight A's. And she said, "Thank you so much for letting me work this out and not removing me, but giving the opportunity to do what I know my daughter would have wanted me to do, which is to take care of her son." So there's so much, I mean, that was not contested. It probably took 45 minutes. But it was 45 minutes because I was allowing her to grieve and speak her piece. And the thank you notes, we get thank you notes. I have people cry in court. I have people thanking me for, I always say to people when they're in my courtroom, "I'm here because you lost a loved one, and I stand instead of that person." And I consider that an honor to do. And within the boundaries of the law, I will try and do what that person would have wanted me to do for their family members, as to the best of my ability. And that, I say that a lot in court, and it's very true. And there's certain days where you just realize how meaningful the work that we do is. And today was one of them for me.
Absolutely. We want to give people the opportunity to speak. It may not be right on point as to why they're there, whatever the legal issue is, but we want to give them the opportunity to speak. And we have that room to be able to do that. So
Judge Fisher, I had a quick question for you.
Sure.
You just sparked my interest in this particular type of case. If the father is still living, or the father was around, and let's just hypothetically say that the father was around, like, what happens then? Does the case go to a magistrate to be handled as some level of transfer of responsibilities or guardianship, or does it go to the circuit court, or is
So in this
everything
case,
handled?
yeah, she had gotten custody through the circuit court, even though she was the default person. She applied to be and was the guardian of the minor's property in the orphans court. She had applied to do that. She got someone to try and transfer the property in a way that wasn't going to protect the minor's interest. So I had to overturn the deed, which is why I think there was 3 or 4 hearings on this, because I was giving her the opportunity to remedy it so that the real property would be titled. You can have real property titled in a minor's name through a guardianship in order to protect that asset until the child is 18. She had gotten custody. I know in Prince George's County, they can do minors, guardianships of the minors person. We can too, but we aren't exercising that currently. But she didn't do the guardianship of the person. She did an actual custody case because I think she wanted to ensure she could enroll the child in school. She enrolled him in Archbishop Curley because he was an athlete and really good in school, and she wanted to ensure that any funds so he inherited everything because the mom didn't have a will. So the minor child is inheriting all of the property in that estate. And then the grandmother was the personal representative, and then she was also the guardian of the minor's property. So she was overseeing maintaining that property for his
Right.
benefit until he turns
But
18.
but if the parent, one parent passes, the other parent is still alive, and all of the assets transfer to the child, does the other parent then, if the grandparent isn't around, does the other parent then get control of the assets of the
They still
child?
have to apply to be a guardian of the minor's property. A guardian of the minor's property is put into a restricted account, so there's a withdrawals by court orders only. So it's on a case-by-case basis, and the court determines, in some cases, school tuition might be appropriate, some cases, other health or medical needs. We have one autistic child who regularly asks for specific special needs. So the presumption is the other parent would be the guardian, but they have to be able to get a bond, and they have to meet certain other requirements like a personal representative, that they don't have any criminal charges such as theft, forgery, etc. And that they meet the other requirements. So for every guardianship of the minor's property hearing, even if it's uncontested, we have a hearing to make sure there's no objection from any other potential interested persons that might come forward. And if the minor's over 14, then we request that the minor appear or sign a written consent that they consent to that person holding their property. When I started early on, there were some issues, and there was a number of cases where the banks improperly released funds to the guardians, because it's not, as I explained to the parent who has the funds, it's not your money. It's the child's money. If there's something that the child needs, the court can, provide that. It's not to provide, food or general housing for your child. That's your obligation as the parent of the child. The guardianship is the child's inheritance, and it's a gift. And we're there to protect that for the child until they reach the age of majority.
Thank you. Thank you. That's a great explanation.
Thanks.
I appreciate you. You guys got a lot of work on the table, I see. And I saw a couple, Monica, you had your hand raised, and then Laura had your hand raised. Did you guys still want to say something, or you guys are done?
I do. I haven't, can you hear me okay?
Yes.
Okay. I've been taking it all in, so I think this is the first time I've talked on one of these. Thank you, Chair Charles. I really appreciate all of the context that you provided. I have one question that just came up as a result of what you said, Judge Fisher, and then I also wanted to go back to another point. So there are cases where someone is the guardian of the child, but does not retain guardianship of the minor's assets. Is that a frequent occurrence?
So just because you have custody or guardianship of the minor, so basically, if one parent passes away, the presumption, and my other background is in family law, the other presumption is that the other parent would have custody unless a third party files for custody in the circuit court and handles that. But just because you have custody doesn't mean you're necessarily going to be the guardian of the property. You have higher priority for us to consider you, but there might be something that you're not able to get a bond. Baltimore County actually has a procedure where we have, it's too much to go into, a limited order where we allow people who are the best person to have the access to those funds to put a little bit of money into a guardianship restricted account. And once the bank signs off it's restricted, then we allow the funds to directly go there if someone can't get bonded. But say you're the parent who has the surviving parent and you have a theft conviction, I can't let you serve as guardian. So it might be another family member, it might be an attorney that we have appointed to be the guardian of the minor's property to oversee that. And they might, if there's a request from the custodial parent, they might request that the guardian request the funds from the court to be released for certain specific needs of the minor child. Did that
Thank you.
answer your?
Yeah, yeah, and I wanted to know if that was a frequent or semi-frequent occurrence, and is that also are lay judges also deciding on those similar type of issues?
They're deciding guardianships of the minor's property. Prince George's County and Judge Groves could speak to that more. So if you're an attorney judge in Baltimore County, we could exercise guardianships of the person of the minor, and we've opted, before my time, opted not to. And since I've been on the bench, we have not extended that. Most of the time, it's the same person who has custody who's the guardian. There's just certain circumstances where there's an issue that prevents them from serving as such. Judge Groves could discuss a little bit more about what happens when they oversee the guardianship of the person of the minor, which I know is something that this task force is considering. I think it's, in some cases it is appropriate to have both of those things heard. Often we have Often it's related to the orphans court because the minor's inheriting property through an estate, which is already in our jurisdiction. I've been told by practitioners that opening the guardianship of the property, we have concurrent jurisdiction with the circuit court, is much faster in the orphans court. So just because we try and keep our dockets moving, I think we're 2 or 3 months out because there has to be even an uncontested hearing to allow objection. So sometimes people choose it, and often they choose it because the estate is already being administered in the orphans court where the funds are coming from.
And do people need to pay additional attorney fees for the other?
So generally, most of the guardians we have don't have attorneys. Occasionally, there's a necessity to have a guardian. We had one where the mom, who was the guardian, refused to close the estate even though the kid was 18. We couldn't find the kid, so I had to appoint a guardian to actually release the funds to provide them to the child. So, but sometimes there's just no one who's appropriate, and so then we'll appoint an attorney to serve as guardian, or in a very difficult situation, sometimes it's necessary to do so, or if there's a ton of money and there might be some other mechanisms for handling those funds.
Thank you. That was really helpful. The other, I'll be really quick. The other piece, I really appreciated Senator West and Mr. Lastly's sort of background context on this. And so, as I understand it, the goal is access to justice for the people of Maryland that are going through this process, and efficiency on the matter of fiduciary adjudication. And so I just want to just level set my own understanding that that means that the goal is for people to get their disputes heard and resolved quickly, that people can understand which judge and which court handles what. People can get decisions by someone with the right expertise. Hopefully people can afford the process, and people in every county receive consistent outcomes, not dependent on the county or background of the judge or population of the county, and that it's efficient, and that hopefully court resources match workloads. Judges see cases that require judicial intervention. The appeal structure makes sense. Hopefully cases that are hopefully cases involving overlapping fiduciary issues are heard in one place, and the registers and courts can communicate well and avoid duplication. Is that, does any of that need correction?
Sounds great, Monica.
Yeah, I think you summed it up wonderfully.
And that's a great segue into the next section, which is the proposals and possible recommendations. And so, Holly, can you bring it up on the screen? She asked that everyone make any proposed recommendations from now all the way up until December 8th.
Yes, that's right, Chair.
You want me to do it?
I don't think we need to share it, Joe, because we're kind of running short on time, but this list, you all can take a look at it. It's proposals that have been talked about at previous task force meetings. They're only potential proposals. A member may choose to bring them forward, may not. I've been just keeping a running list going. I'm happy to add to it. Like Chair Charles just said, please just send it to me. You don't have to add your proposal. You can still introduce it on December 8th. I think this document is meant to just help pull ideas together and start the discussion for purposes of preparing for December 8th. And then separate and aside, it's not on the agenda, but I emailed all the orphan court judges in the state that hearing schedule and the educational chart that we talked about in a previous meeting. And I asked them to update their personal education and their specific personal education and their county schedule. And if there is any changes, please email them to me as soon as possible so I can update that chart. I'm happy to update it. We want it to be as accurate as possible. I've only heard from 3 judges so far that had minor changes, but please, now that we're live, I just wanted to reiterate that I've emailed it out, and I'm hoping that we can make it as final as we can because we're going to post it onto the website.
Thank you so much, Holly.
Thank you.
And I know it's 7:24. Please take a look at that information. See if you like it, if you don't like it, because these are possible recommendations that are going to be brought forward. And Holly, has that draft been open to the public so they can kind of take a look at that as well?
Yes, it has. It's under meeting materials.
Okay, so for any of the public who will join us at the next meeting, you can look at those recommendations and agree or disagree with any of those recommendations, and we'll go from there. And then finally, we got the analyzing the preliminary fiscal information of fiduciary adjudication scenarios related to structural changes. We've got about 5 minutes until we close. I don't know how fast we'll be able to get through this, Joe, Monica, and Jonathan, but we can try to. And I have to step away for a quick second, Delegate Bartlett. So can you take over?
Okay, thank you, Mr. Chair.
Sorry, Joe. I was just saying yes to. Oh, okay. I thought you heard me. I was just saying yes to the chair.
Okay, thank you. Can everybody see my screen? Okay, I'm just going to broad brush this given time, and this is a document for you to look over and study, and hopefully it's helpful. It's not working. Okay. This presentation is just, it's fiscal information. It's not a fiscal estimate. And just to gauge some of the different fiduciary adjudication scenarios that the task force might consider. And the information is focused on personnel costs, annual personnel costs, salaries and fringe benefits. I didn't look into, and I had the help of a couple colleagues, a lot of help. We didn't look at overhead costs like courtroom and office space or data programming costs that might be involved in any kind of change. And the change we're talking about is shifting caseload. It's not an increase in cases, it's shifting caseload between different courts. Due to time constraints, this was developed without input from the Judiciary, the Register of Wills, or the Orphans Courts. I did use the fiscal worksheets that we use in DLS to do the salary and fringe benefits. We also did not allocate the cost between the state and the county. That is something that the General Assembly may do, but that's something we didn't do. So these are just statewide costs, not allocated. Now I have 4 scenarios, and each of the 4 scenarios are just examples, and this is not to restrict the thinking of the task force, it's to encourage it. These are not the only options, as Holly said, for the working document. These are just some scenarios that Jonathan offered. So, and there could be a lot of modifications and variations of any of these scenarios. So that's all they are. There's some assumptions. Each scenario has a low cost, a medium cost, and a high cost. And it's not based on caseload, that we didn't have time to do that. For some background information, the circuit court judges, their costs currently are paid by the state. The operating costs of the circuit courts are paid by the county. So there is a hybrid situation in the circuit courts. Magistrate judges, which are part of some of these scenarios, their salaries are paid by the state. The orphans court judges, their salaries are paid by the county. So that's the current personnel cost structure. This is part of the blue chart that we talked about earlier in the meeting. This is caseload. Again, you can look at it later. These are the 8 judicial districts, the counties in the districts, the number of circuit court judges, the number of orphan court judges, and the number of orphan court cases for fiscal year 2025. You can see how there's some symmetry and proportionality here. Judicial Circuit 1, 2, and 4 have about the same number of cases. Judicial Circuit 5, 6, and 8 have about the same number of cases, and Judicial Circuit 3rd and 7th have about the same number of cases. And again, I apologize for going through this so fast. The personnel costs that we use, compensation, circuit court judge, salary and benefits for fiscal year 2026. And the data is all based on fiscal year 2026. That is the salary for a circuit court judge. Every circuit court judge gets a law clerk and a courtroom clerk. It's a 3-position package. And those are the salaries for a law clerk and a courtroom clerk. So one circuit court judge, this would be the number 486,276. Sometimes the court, the county court, the circuit court will hire a judicial assistant, and that's paid by the county. Full-time magistrate judge, that's the salary with benefits, a half-time magistrate judge. And in a couple in these scenarios, there is an orphans court judge that would represent a circuit, one of the 8 judicial circuits. We assume that that cost would be at least equivalent to a full-time magistrate judge to attract a full-time attorney. And of course, the circuit court judges are set through statute. We have an assumption in here about the personnel costs for the current orphans courts across the state. This is the average salary across the state. And you're going to see a 2.5 million figure, which is 80% of the total budgets of all the orphans courts in the state, which was 3.1 million. So the total budgets for the orphans court in fiscal year 2026 across the state was 3.1 million. We took 80% of that as compensation salary, which is 2.5 million. And I can explain the rationale why the 80%, but 80% of the 3.1 million is, we think, related to compensation. The balance would be overhead, which we didn't take into account. The sources for these scenarios are Jonathan Lastly, who's a task force staff member. I've got the salaries from the Maryland Judiciary, the Circuit Court Magistrate salaries. The orphan courts budgets came from Byron. This 2.5 million assumption I just mentioned, that's from DLS, and the fringe benefit calculations, we used our fiscal worksheets, that's from DLS. Okay, here are the 4 scenarios, and I have details. Each scenario has all this detail, which I can't go over, but the first scenario is the orphan court judges are full-time attorneys, and they are going to expand their jurisdiction by handling probate and non-probate matters within the orphans courts. So the shift is from non-probate fiduciary matters. The shift is from the circuit courts to the orphans court. That's the first scenario. The second is the orphan court judges, which again are full-time attorneys, handle fiduciary matters within the judicial circuits. The eight judicial circuits each have an orphans court judge, at least one, or maybe we did different combinations. And there's a magistrate judge in each county. So again, the shift is fiduciary matters from the circuit courts, because this is all fiduciary, trust, guardianship, to the orphans court, but based on judicial circuits. The third scenario is the circuit court judges handling fiduciary matters within the existing circuit court structure, which is similar to what's going on in Montgomery, Hartford, and Howard. In this case, the caseload is shifting from the orphans courts to the circuit courts. And a variation on that in scenario 4 is creating a fiduciary division, but this would be, again, with the 8 judicial circuits. And when there's a judge with a judicial circuit, we have the magistrate judge in each county who's handling, most of the uncontested routine matters. And again, in this scenario, the caseload shifts from the orphans court to the fiduciary divisions in these circuits. Okay, I see my time at 7:35. I was just going to let the task force read through these. If you have questions during the week or next week, however the chair wants to handle it. These, again, in each scenario, we have a low cost example, a medium cost example, a higher cost example. These are just rational assumptions. They're not based on caseload. I gave the caseload just to give some context. And this is what it would cost under these scenarios. This is what the 2.5 million that would be saved, if you will, because the orphan courts would not function as they currently exist. And this is the difference. So this is the net difference, I guess the net cost, if you will. Okay. So I've got that first scenario, the second scenario, and you can just read through and see every one costs. This is the least expensive. I mean, every one of them costs something, but again, this is not set in stone at all. Okay, and this is, I just don't have time to go through this, and I apologize.
So, Joe, thank you.
Yes.
I think this is good detail. And while we'll have our public meeting, perhaps, I don't know if we can have some time, as you mentioned, for questions for this on our next for our next meeting.
Yes.
Hopefully. Okay, great.
Yeah, I'll stop here and then again, if you have questions during the week, or we can, however you'd like to proceed next week, I'm happy to spend more time on it.
Delegate Bartlett, I think what we can do is after the public speaks, we can open this up briefly for some questions if anybody has them, but please feel free to email Joe and me if you do have questions so we can get ahead of it, because we are running on a very compressed timeline. So if you do have questions, let us know, but we can certainly bring it up and open it up briefly before before we move to the next agenda item for next week.
Okay. And so Delegate Kaufman, do you want to hold your question until then?
Yes, I have a question, but it's 7:41, so I think I might hold my question if that's what you prefer, Madam Chair.
Well, is it a quick question? Is it on the material Joe just covered?
Yes, it is.
Okay, so why don't you hold your question until, if you don't mind, hold it and ask Joe maybe either an email or something, so that if you want to ask her offline, or you can ask her online next week.
Okay, yes, because it's getting late. So yeah, I'm happy to hold my question.
Okay, great. And I don't see any other hands. So I am going to thank you all for a productive meeting. Thank you, DLS, Joe, and Holly, as always. Jonathan, everyone, thank you for your input. And with Mr. Chair's consent, I'm going to go ahead and adjourn the meeting. Thank you all.
Madam Chair,
I'm sorry.
I just want to point out that we have opened the sign up for the public hearing, and it's open. It's under the meeting materials. You'll see all the details for December 1st on the task force's webpage, but you need to send an email and sign up officially with us to speak. And you can also submit testimony if you just want to submit testimony, or you can do both. But all that information is under the December 1st meeting details. And that sign up will close November 28th at 5:00 p.m. After that, you can submit written, but we're not going to take any more speakers after November 28th, Friday, after Thanksgiving at 5 p.m.
Great. And Holly has provided all of us with that information so that we can share it with other folks who we think may be interested in providing testimony in our next meeting. Thank you very much. Have a happy Thanksgiving, everyone, and we will see you all December 1st.
Happy Thanksgiving.
Happy
Good night.
Thanksgiving.
Happy Thanksgiving.
Happy Thanksgiving.
Happy Thanksgiving. And Delegate Bartlett, thank you too for taking over.